And then I wasn't having kids.
Yeah. Okay, it's 10:50. Let's go ahead and get started. I want to remind everyone that today's lunch will be from 11:30 until 1 p.m. in Grand Ballrooms A and B. That will be from 11:30 to 1. We'll reconvene here at 1 o'clock for our next session. We're fortunate enough to have some heavy hitters with us here today. We've got Perry Mason and Matlock with us to give us their wisdom. Seriously, we got John Johnson with us. He's a staff attorney at D9 from 1999 to 2019. He's currently assistant general counsel from 2019 to present. His work areas include eminent domain, regulatory law, hearing officer, and workers' claims. He enjoys farming, fishing, amateur radio, and spending time with his family. We also have Kyle Ray. Kyle started with KYTC in 2017. He currently serves as Assistant General Counsel in District 7 Lexington office. Outside of KYTC, he enjoys sports, music, and spending time with family. Go ahead and turn the floor over to you guys.
My name is John. This is Kyle. Of course, I want to make sure we got that clear. Which lawyer? Matlock. Perry Mason is a little heavier, that's why. I started the cabinet in 1999 in District 9, Fleming Park, Kentucky, and essentially the first thing that I was told, and I think it's true to this day, is we don't care about the case after we get right of entry. But you have to get right of entry fast. I agree with that. That's that when I started with a different occurrence than it is today. When I started, everything was prepared, everything was smooth. We would get 12 lawsuits at once. We would file 12 lawsuits at once. We would get 12 sets of commissioners appointed. We would get commissioners' reports all within a couple of weeks. Then we would go to court, request our money to the commissioners' award. We go to court, get right of entry. And we went the process. As a rule, back in the old days when I started, we could actually get commissioners appointed immediately. Get to the current problem we discussed. When I mean immediately, before it left the file, we delivered to the judge would sign, who they knew would be the commissioner's names all over the documents. And it would be handed over. They would call our office, we would send an engineer out. or right away agent out to read the plans with commissioners within 15 days as required by statute. And we were off to the races. Never did we have any problems with computation errors in the commissioner's report. Never did we have any problems with commissioners being appointed. And never did we have problems with commissioners going out and meeting the landowner to see how much money they want. That was sort of a lot happened back then quite often. But we, am I too far? You really want me to do that? So that was 20-some years ago. Now, if I take the same dozen or so cases in the courthouse, the judge may not even look at the file or the order appointing commissioners for 6 months. And in some cases, as is recent in my district, 9 months. And you call the judge and they won't come to the phone. I've got that going on in 3 counties right now. So I threaten them, they threaten me. Kelly Vine threatens me, Dean Wood threatens me. But this is how, I don't know what's going on, but I'm going to give you that as an example before I start getting how it's supposed to go. But things have changed, and I know as far as jury trials, when I started, jury trials were fast. We could try 3 cases I tried as high as 2 or 3 cases a week. They don't go that way. Now we have COVID. So if you have a case set for trial next week, the week after, the judge may call you out of blue and say, we have a criminal case. We're sorry, but we're going to move your case to another date. It happened recently to the dean. We had one set in May, and I got a phone call out of Green County. Green County says, "Judge, we're going to done. I don't care if you mind, but we asked for permission, but we're going to do it anyway." And we moved it to May of next year. So what all this adds up to is it delays the process. Never before have we had such opposition. Now, I've not got to the part about the right to take challenge. We'll say that for later. But this is how it's supposed to work. I know you've talked about suit packets today. They start with a parcel summary. I don't need to go through this entire list. But when you create a suit packet, they're assigned to us out of the central office. And if you notice, if you get an email from central office, it goes to Kelly Baden, Dean Lloyd, Mr. Beevan's on the list, and a whole lot of other people, including Shannon and others. I mean, we have 6 or 7 people. From that day, usually we get the packet before, but from that day forward, we have 35 days by our guidelines to submit a finalized prepared suit to the clerk's office file. And what's got to happen in those 35 days? The first thing we do is we go through and we look at the title report. I've been asked to emphasize this because what we're looking for in the title report is we want to know who the owner of the property is. That's extremely important. And by title report, it is the title that's in the clerk's office, not what somebody told you while you were there. And I'll share a story about that later, but occasionally people think they own property they do not own. What is the owner in the county clerk's office is the owner in the courtroom. Anybody who says they own it, they're not listed by name on a document or by document by a source deed conveying in the property by virtue of an affidavit of descent or some other indicia, maybe a will, which says that they own the property. Absent any of that, they don't own the property unless we have something to show. Now, you live in the mountains, you learn, people sometimes don't do deeds for every 50 years. That's how it's been done. That's how their daddy did it, and that's how they're going to do it. And if they do it right, they don't have to pay property tax. And occasionally they'll transfer property several times without doing property tax. And what's been brought to my attention recently is occasionally they'll have a landowner sign the deed. Kelly, remember that recently? Yeah. They think that they can do it. That's one thing that they reserve only for lawyers because it's simple. We can't screw it up. All we have to do is sign it. There's a little paragraph on the back that's prepared by Keith McDonald. You know this is true. We can't screw that up. But we've had a title recently where the named owners had not only prepared the deed, but had signed the deed as preparing attorney, and they weren't an attorney. deed's invalid. So we know how to fix that. If you ever have that come up, you need to come to your attorney or contact Dean Lawyer or Kelly Devine and try to fix it. But the reason that's important is we gotta know who the real owners are, and they need to be listed on the title. And there's a lot of them in the room that work with me, and if they would, and Amy's not here, but she's our paralegal in District 9. If we get a dozen titles, how many of you, before I get real filling daggers, how many of you here work with transportation cabinet? How many of you work with consultants? Okay. How many of you work with transportation cabinets before you went to consultants? About the same number, okay. We all know what I'm talking about. There's no underestimating how important the title is, because if the title's wrong, we sue the wrong person, and they'll gladly take the money in many cases. Would you believe that's happened before? And what happens when that happens? We pay for the property twice. That's one example. We had property in Fleming County, which I didn't do the title on, neither did our people. Duly noted. Our people do a really good job in District 9. We went out and condemned the property. The landowner knew that we didn't have everybody listed, and somebody co-signed on a loan over an adjacent county, and they didn't make their mortgage payments. Wasn't in the chain of title, but it was on the, they said it was on the chain of title, but it wasn't properly indexed. Is that how it happened? That cost us how much money? The $92,000. So, gotta know who owns the property. The title's gotta be clear. We get the title, we like to have every document referred to in the title. Not because the title's not done properly, but I hate to throw, are they lawyers in here other than Kyle? Good. Steve, you know, you're smiling, you don't get ready to throw the lawyers under the bus. If we get contract attorneys to do titles, they are the worst. I would much rather have everybody in District 9 go run and do a dozen titles than a dozen attorneys with local law firms run over and do the titles. And if we get 4 titles out of a consultant, attorney, law firm, 3 out of 4 will be wrong. We have to send them back. Dean Wood wants us to send them back. We're paying them to do it right, and send them back. And anybody in here attorney now, the consultant attorney. Good. People talk, so don't spread that around. We've had a tremendous amount of problems with that. So what happens when that happens is in the District 9, which we send it right back out, and our people have to go do the title. Anybody in District 9 had to do that lately? Ladies? Jeremy? What happens there is we end up having to redo what the consultant and the clock's ticking. So when our right-of-way people get our packets, so double check the titles and make sure they're right. We don't have a problem in District 9 because they know what to look for. They know to look for deeds and wills and make sure they're attached. Marriages, divorces, some things may not even be a record. Ask around if you're in the county clerk's office. Hey, you know, Kyle, is he married? They should know. Most of the time they do know in a small town. Large towns, you're not going to be able to get that kind of system. But you can also look that up in the clerk's office. Condemnation pay statement. Getting into the right to take challenge. There's only 3 grounds to contest the right to take. And I'm going to talk to this and turn the rest of the section over to Kyle. Fraud, bad faith, and abuse of discretion. How that was to make it a part legal faster. It's one play. Fraud, bad faith, and abuse of discretion. Which one do you think the pay statement involves? It's related also to the contacts. Bad faith. Absolutely right. Who said that? He's a hero. He's been there. We have a case in Kentucky that says bad faith occurs when we fail to offer. This is paraphrased. I can't believe there's a case that has to do with compensation. We cover that with Mars because we're basing it upon a stated value in comparison to sale, even though we're not doing specific appraisal. I'm still not doing this. most usually, federal law and state law requires fair market value appraisals. We get away with them in MAR because of the safeguards that are placed in the case on that. I may not agree with it, but there is a case. Pay statement shows that we negotiated. We talked to the landowner, we said, this is what our appraiser said, am I right? This is the way the contracts, and all this stuff's gotta go together. So I get to sue, and we sue somebody, in District 9, I can establish not only that the pay statement was part of there, we made an offer, and I'll see, and I haven't got to the appraisal yet, but all those things have been considered, because the first thing happens when I file a lawsuit is, if Shannon went out there and she didn't offer me enough money, that's not a problem. Not enough money is not a problem, so money's not an issue. It's if they did something wrong or didn't use it. There's two ways you get to bad faith. One is you appraise the wrong property. Cecil, have you ever had that happen?
Sure I have. Sounds like off the top of my head.
The other one is you use the wrong, Shannon, let's close your eyes over there for a minute. But there, you can think of, the other one is that we don't base our appraisal on comparable sales. The two examples that come to mind. Quite often in the suit packet, there'll be a letter where you tell them that this is the offer, the suit letter, and the formal letter offering money, whatever, that we send out to the landowners and kind of give them the last week, this is what we're basing this on. Now we hand over a copy of our appraisal or MAR, say this is the reason we're offering this amount of money. And that satisfies, in my opinion, the good faith requirement in negotiation. We've got a basis for the offer, it's based on some fair market value that we arrive at, and we're talking to the people. We're not just ignoring. That's relevant because it's the first thing that comes up in a mediation, is they never talk, nobody talking. Sometimes that happens, but that's important. But the next thing that's really important, and this walks into more, all the cameras going on, and these people. Back to fair market value. One of the things that's key is not the first offer, but the second offer. Anybody think about that? Years ago, we had a right to take case, Pike County, involved in Pike County School Board case. Came up in Carter County, Kentucky. You remember one of your predecessors, Shannon, I'm not going to mention her name here. I go to church with her. She came from a long line of right-of-way agencies, basically, and said, take it or leave it. We only make the one offer. Will, you were there, Berkeley, you were there. I'm not going to mention names, but that actually was our testimony in the trial. We only make the one offer. Even witness this last minute. That's a bad faith negotiation. So you got to give them an opportunity, come back at you with a counter offer. And all you have to do is consider. You don't have to agree with it, but you got to give it some consideration. But that wasn't how it used to be. It was like, well, it's just one offer. That's all we ever did. And we're right and you're wrong. Bear that in mind. Another important thing on the titles and names and addresses. Kyle, do you want to? We were talking about this earlier. Occasionally we'll get a suit packet and it's down by the, they live in a van down by the river. We really get that kind of, we don't keep, I'm telling the truth. There are a lot of people that don't have addresses for many reasons, but that you need actual physical address, not post office box. It can't be PO Box 119 such and such. It has to be whatever the actual address is, street address somewhere, because when you file a suit, it has to be served by the sheriff or certified mail. They have to have a direction to go with it. They just can't run it off the post office. But on occasion, we don't know where anybody lives. How you need to address them know theirs. We don't know where they live. What do you do, Kyle?
Alan, it's nice to meet some of you all. We've not had an opportunity to meet. I'm the district attorney for 7 in Lexington. I do some condemnation work. I'm also, I don't think you'll deal with advertising devices, billboards, but I spend a lot of time dealing with that as well. But when it comes to unknown errors and when it comes to just getting information, one of the most important parts for us to actually move any case forward is actually getting people served. John was talking about how delays can happen with commissioners getting appointed. But generally the biggest issue that we experience when it comes to delays is getting people served. So providing us with the addresses so we could serve people that are not LLCs, not corporations, actually makes my job and any other attorney's job exponentially easier. Because we don't actually have those contacts that you all have when you go out to make offers. And I very much understand some people don't actually want to talk to anyone who goes out to make an offer. So the truth is those making an offer have a very difficult job, but a very important job because your all's experience with the property owners is essentially almost the most important part actually for my case. The experience that the property owner has with the agent coming out and making an offer impacts everything that I do. And I'm very lucky with some of the guys here in Gallatin District 7. When they go out and make those offers, even if the case ends up in condemnation, I'm not having to backtrack to build a relationship. So if there's anything I leave you all with today, please know that your all's contact and experience with property owners is honestly the biggest impact in my case when I get it. And it is well appreciated. I want you guys to know, District 7, I appreciate the work you all do because it makes my job a lot easier. But so getting that address allows us to get the party served. And if I get the party served, I can get right of entry because I cannot get right of entry until parties are served and 20 days is lapsed. So having valid and good addresses makes everything exponentially easier to get in right of entry. But when it comes to unknown entities, if you can't find somebody, don't know where their address is, at the end of the day, I just will provide a last address for that entity, that person, and ask for the appointment of a warning order attorney. And so the appointment of a warning order attorney actually creates service the day that that attorney, the warning attorney is appointed, and they have 50 days to file an answer. So there are many times that is the way that I will proceed with the case if we don't have an address. But having an address makes it considerably easier and less of a cost. But if you do not have an address, that's not going to hold up my process if that's the situation. One of the things that John and I thought when we came up here, and the truth is, a lot of us, we don't know each other. John and I can ramble, or we can also answer questions if that would be beneficial. So if people have questions, please just raise your hand, and that may actually be more beneficial to you all than us talking about topics that would not be beneficial to you all. So, and I'll be honest, if you all can hear me, let me know. I actually don't need to talk into a microphone and tell me that I need to so people online can hear. I was generally just going to speak loud enough so you all can hear. So if it goes in and out, I apologize. This is not something I'm going to do.
Are there any questions?
Yes,
Can we throw you a softball?
the gentleman, the good-looking gentleman there in the fourth row.
Kind of talk about your,
Thank you, yes. Kind of going back to what you were talking about with not being able to find people. Case we just had recently in D7, I don't believe we could find the minor, owner of the property in Madison County. It took us forever to even locate that person, and they were a minor. So that drug that route of entry out way further than, you just want to kind of walk through that just a little bit, because that was terribly confusing.
Yes, we had a case where, essentially, mother had given her property to her 4 children. And in the situation that one of the 4 children died, her grandchildren by that individual was to step in their shoes. In that situation, the son that had died had 2 minor children at the time she died, and the property was put in trust. But we also had to deal with a minor who no one in that family had seen or spoken to in 14 years. So it essentially resulted in an inability to actually find a guardian for that person who could negotiate with them. And so what we ended up doing to actually attain clear title was file the lawsuit, condemnation action report, and had a guardian ad litem appointed for that minor. And so through the court process, the appointment of the guardian ad litem actually serves to represent the interests of that minor in the lawsuit. And so through that representation, that attorney is allowed to file a right to take if they want to. They almost never do. They did in this case. They essentially are a placeholder that allows us to move forward with the case and then talk to that attorney directly for the minor. And essentially we were able to get that guardian ad litem appointed in that case. The commissioner's award was came back with a report. We posted that and actually able to get right of entry by having that guardian ad litem appointed for the minor. And actually ended up as recently still in that case. But in that case, and dealing with minors in general, it's very, very difficult. And there's actually a statute that when you're dealing with minors, there actually has to be a guardian appointed for them either through the district court, or you end up having to be in circuit court in a condemnation action. You cannot settle and obtain clear title where a minor owns a piece of that property without actually having a guardian appointed or going through the condemnation process. So in this situation, since we did not know where the minor was, couldn't talk to her, didn't know how we're going to get a guardian appointed, it just made sense to go through the condemnation process after talking to all the other parties. So I think that what the situation is there, Cecil, you're dealing with a minor, you're not obtaining clear title unless you get a guardian appointed for that minor, which is generally the parent in district court, or you end up on a condemnation action. And from my perspective, maybe people will disagree. I think the condemnation actually makes it faster. Should not have to go to district court to deal with the point of getting just the right of entry portion. When it comes to money, that is a separate issue that can be done later. But any thought issues on that question, or then my answer makes sense? Any other questions? So I'll continue on with what you're talking about.
Thanks, Kyle. I knew Kyle had problems unknown.
Please.
How many KYTC attorney positions are filled, vacant?
Not enough.
Is the OLS typical right regular? Low typically disagreement in offerment?
Could you break that into 2 questions? Right now, we have a number of vacancies in the Transportation Cabinet Office of Legal Services. District 2, District 3, and District 10. And there may be a vacancy or two in the central office. What was the second part of that question?
Is the OLS right-of-way work load typically disagreement in offer amount?
Almost always. So. The other two prongs of right to take, I'll go back, bringing in that. Which is not a grounds to contest the right to take. Disagreeing on the value of the property is not ground. Yes, yes.
Not they'll make it file right to take.
We will get there.
That be what you're talking about.
We will get there.
I should point out that there are, at least when we're dealing with stuff in District 7, there are other reasons other than money why people will end up not wanting to sell their property. I will say though that money generally does take care of all problems if there's enough of it.
That's what it always comes down to. We have historically want to go the record on right to take. I don't think we've lost any legitimate cases in the history of the cabinet. Well, there have been a couple. There have been a couple. One was in Northern Kentucky that statutory the legislature exempted. It was in a monastery. Siri, one of our predecessor attorneys, got hammered on that one. It was accepted by the legislature to never be condemned. And there was another one where the official order number was wrong, which that was quickly remedied. I'm aware of one where an offer was not made, and all we had to do was dismiss the suit, refile it, and correct it. We did not do that. So the other option, KRS 177081 is where the right to take challenges come out of. And it's based on whether or not it's a public use, public purpose, whether or not the project's necessary. We talked about bad faith being compensation. The other two elements, fraud and abuse of discretion. So I can't think of any reason why we would fraudulently condemn property that's not for public use. But I'm sure it was case law in some other state. We don't spend money unless we need to typically. But one argument might be is that we're condemning the property for private use instead of public use. In that case, that would fall under there. We are by statute and by constitutional law prohibited condemning property for private use, which we can't condemn property to put in a supermarket, golf course, horse park, maybe. Got to be lenient a little bit. It has to be for transportation. Our purpose has to be a highway, bridge, and supporting structure. And abuse of discretion. I always see that argument in the right to take challenges, and typically what that translates to the landowner is you built the road here, but why didn't you build it over here? And like Kyle said behind the scenes, and by the way, you gave landowner A and C 10,000, why'd you give me 5? Because they all talk after you leave. But somebody nod their head yes. But that one is abuse of discretion is not an argument that ever carries weight, or I haven't seen it carry weight yet. But Deanie, we got one coming like that. They're going to have to establish who's our attorney on. Okay, we'll talk about that later. If you want to give us the facts or
Still,
litigation.
I'll quote the attorney lingo, it's still in litigation, and we probably don't need to discuss it.
Okay.
You know, for public consumption.
Initially, when I started practicing, most of the older attorneys would not even go there. Because what happens is they end up wasting time, they waste client funds, and they drag it on forever. And usually at the end of the day, we're only going to go what the fair market value will allow us to go anyway. We can't settle cases too far off the fair market value, and we just can't give people more money to let stuff go. We have to have a reason for it. And you all know that being right away, there has to be another sale, There has to be more damages. There has to be a reason for it. We just can't, well, they want 24,000, let them have it. Yes, sir.
Do you find that the representatives for these property owners, don't obviously are not as well versed in the condemnation process? So they say that we don't have the right to take, or they try to challenge and say that we are using our discretion, because that's happened to me on a couple of where they challenged one of the property owners, attorneys challenged our entire project, saying that we literally built it to take this person's property, take their house, and obviously our attorney was able to argue that out. But my point is that with these judges and attorneys today, does that create more of a problem for us if they don't matter?
Well, if you go back to the eminent domain act, was initially it was common law, but in the mid-70s, then the eminent domain act was passed to codify specific procedures we go through today. All the case law, even most of it predates that codification of that act, so you'll see that. Yes, in answer to your question, in the 60s, when we had the national drive to go interstates, build interstates everywhere, Eisenhower administration started that, and we built them all the way up to the 70s. And we're still on some of these bigger roads. People get that, and during those time frames, District 9 had 4 attorneys. No way. Was that 5? And yes, the older attorneys and the older judges knew the law better. They would never, ever raise a right to take challenge. But the second part of the conversation is nowadays, it's common because the attorneys either pick it up in a bar association conference as a way to make more money, or they just look at it in a statute and just throw it out there just to try to delay the project. I've only had one that was legitimate where they actually tried to delay the project because they thought it was a historic property and turned out not to be. It was in Carter County, Rock River Curve. All the others, we've had probably a dozen since then. None of them have been legitimate. They don't have any facts to back their argument up. And if the judges today on the bench who've not tried a lot of these cases don't know what the law is. So what we try to do is we try to, if the judge asks and they'll cooperate, we can hand out, we have a way of giving them outlines of the law and let both sides see it. And I try to educate the lawyer, look, the only thing that's admissible is the comp, before and after values of the difference, the highest and best use, and what our witnesses think about the property. We'll put an engineer on the stand or a right-of-way agent to tell you what's been taken, what it looked like before and the effects. We should be out here before the end of the day. And money's the issue. That's what it used to be, not anymore. You're right. So it's a function of, gee, you can't be serious. So 4 minutes is not run by. Any other comment? Did that answer your question? Right now, it's getting to the point that it's common. Every project, they just do it for fun. And what it does, is we should have right of entry within 6 months in most cases, unless there's a problem. Hopefully 2 months. But what that does is delay it. It's an appeal of right, first appeal before appeals, appeal of right. You're looking at a year or 2 years to get it back from the court of appeals. Then they're entitled to file for discretionary review of the Supreme Court. Which case I've been there, it drags it out 4 or 5 years.
John, I wonder, I don't know how many people, are dealing with, when they go to talk to property owners, and obviously we're here to talk about the condemnation process, but are dealing with people talking about access. And they're claiming that they should be compensated for their access. I just want you all to know that access is not an actual issue of value. The issue of access, is it reasonable or is it not reasonable? It's a purely legal issue to be decided by a judge. It is not supposed to come up in the actual trial regarding compensation. I know there's judges that are allowing that, but the law is access is a legal issue to be decided by the judge before the trial of damages. So if if you are having problems with that, I'll be happy to send you the case law if you have that. But I realize that that seems to be a occurrence that's still happening over and over and over again when it comes to access.
The huge problem with the, I'm sorry, I'll object, but it's a huge problem with us because we're arguing with some of these business owners that are screaming. You're taking away prime access right here and shipping it down, you know, maybe 500 yards where it currently is. They're going to lose, you know, X, Y, and Z amount of dollars. And I don't see how, I mean, they were scouting for some of that, you know, the price, some of that was addressed, but in their minds, they're thinking, no, you know, it's not enough.
As Kyle said, there were over 8 cases to deal with accidents. Carlisle's a landmark case, Lee case. There are over 20 cases that tell us in Kentucky law that business losses are not compensable. So ever how you look at that, and the only way, the way we're gonna have to deal with it is let the judge rule against us and then appeal it. That's it.
Some of y'all may know Louis Kawaja. He still works in District 7, he's been protected 50 years. He actually was returning to establish a case in Lexington where access that was moved a mile away was actually determined to be reasonable. So the case law in Kentucky is very much on the side of the cabinet when it comes to access.
Homer case. Carlisle case is another one, and there's Gibson Brothers Furniture in Boyd County. We finished.
I guess we're finished. Want to remind everybody that the lunch will be served in grand ballrooms A and B. It will be from 11:30 to 1. And at this time, we'll reconvene at 1 o'clock for our next session. Don't forget to fill out your evaluation for this session.